The township is the basic unit of measurement in the rectangular survey system. What does a real estate township contain? Each square, 6 miles by 6 miles, is called a township. Townships are subdivided into sections. Since each township is 6 miles by 6 miles, township contains 36 square miles, each one forming a section. Each section is 1 square mile or 640 acres. Lot and block description: a description of real property that identifies a parcel of land by reference to lot and block numbers within a subdivision, as identified on a subdivided plat duly recorded in the county recorder's office. What is an example of a lot and block description? A lot and block description will simply list the lot number, the block number, the subdivision, the county, and the state. So, a description might say Lot 2, Block 4, Oak Hills Estate, Johnson County, Kansas, and that's all. That would be the legal description, also called lot block and tract system, or subdivision system. What is the definition of a subdivision map? A subdivision map is one of the processes used to subdivide real property into smaller lots. Typically, the subdivision map is used to create five or more residential lots. A plat map contains all the details required to subdivide, merge, or develop a property. It contains the property divisions to consult when selling or transferring ownership of a property. A plat map also defines property dimensions to guide the development of natural resources or constructing new buildings. What is a plat map in California? A plat map is a diagram and is used to show how your purchased property is divided within your county, city, or neighborhood. It serves as a guide to a tract of land that has been created by licensed surveyors. The plat map is drawn to scale to record the plots of land and property boundaries. In a meets and bounds legal description, the starting point of the survey, situated in one corner of the parcel, all meets and bounds descriptions must follow the boundaries of the parcel back to the point of beginning. Unit 3, land owned in fee simple is owned completely, without any limitations or conditions. This type of unlimited estate is called absolute. A fee simple is generally created when a deed gives the land with no conditions, usually using the words like to John Doe or to John Doe and his heirs. What is the definition of fee simple in real estate? Thus, fee simple means the maximum interest in the property, being unqualified, of indefinite duration, freely transferable and inheritable. When the certified appraisers of the assessor's office value property for property tax purposes, the law requires that we use the unencumbered fee simple value of the property. Which is the best definition of a fee simple estate? Fee simple is a legal term used in real estate that means full and irrevocable ownership of land, and any buildings on that land. Fee simple is the highest form of ownership. It means the land is owned outright, without any limitations or restrictions other than local zoning ordinances. What is fee versus fee simple? Fee: a right in law to the use of land that is a fief. Simple: a in the unconstrained sense, without limit to the inheritance of heirs, unrestricted as to transfer of ownership. What is an example of fee simple estate? Fee simple and encumbrances. For example, if a fee simple estate owner has a neighbor who has built a structure or put in a landscaping feature that goes over their property line, they are having their ownership rights encroached upon and are being prevented from having complete control over their own property. What are the two types of fee simple estate? Fee simple estates are the most common and grant a complete interest in land. It's yours to be used without conditions or limitations. There are two kinds of fee simple, absolute or defeasible. What are the main characteristics of the fee simple estate? The greatest possible interest in real property. The estate is unconditional, unlimited, and perpetual. Why is it called a fee simple? An interest in land. Land owned in fee simple is owned completely, without any limitations or conditions. This type of unlimited estate is called absolute. A fee simple is generally created when a deed gives the land with no conditions, usually using the words like to John Doe or to John Doe and his heirs. What is another term for fee simple? Fee simple is a term used to represent the maximum ownership interest in real property that is allowed under the law. It can be referred to as complete ownership. Are condos fee simple or leasehold? The vast majority of single-family homes are fee simple. Most condos are leasehold rather than fee simple. What is the opposite of fee simple? Fee simple ownership requires no rent be paid, though property taxes still must be paid to the local and state government where applicable. A leasehold requires rent be paid to the true property owner, and depending on the terms of the lease, the lessee may also pay property taxes. Does fee simple mean no mortgage? Types of fee simple ownership. The owner can do anything with their property as long as it doesn't interfere with others' rights. The owner can sell, dispose of, mortgage, lease or otherwise transfer their property without anyone else's permission. What is freehold versus fee simple? A freehold estate is an estate in which you have exclusive rights to enjoy the possession of a property for an undefined length of time. In contrast, a less than freehold estate is held for a fixed, defined period. Fee simple absolute is the greatest interest in a parcel of land that one can possibly own. What is the most common form of ownership? Fee simple. Fee simple absolute ownership. 1. Fee simple absolute ownership. Fee simple absolute ownership is the most protected and most common ownership status for a freehold estate. While fee simple absolute owners must pay property taxes and follow local laws, they otherwise enjoy complete ownership of the property. What is an example of fee simple ownership? An example of this is the life estate, which we mentioned earlier. The inheritor of a life estate gets fee simple determinable ownership of that property. What rights does a legal fee simple owner have? The term fee simple refers to an individual's absolute ownership of land. It is the most complete ownership interest an individual can have in real property, and with a fee simple title, the owner has the right to possess, use or dispose of the land as they choose. A life estate vests the beneficial use of property in a person for their lifetime. The person who holds the life estate is the life tenant. The life tenant may have the right to occupy a residential property and or the right to income from property that is rented or leased to others. What best describes a life estate? A life estate is property, usually a residence, that an individual owns and may use for the duration of their lifetime. This person, called the life tenant, shares ownership of the property with another person. A life estate is property owned by an individual during their lifetime and prevents beneficiaries from selling the property before death. A life estate is created by a deed that gives the land to the person for life and identifies what should happen to it after that person dies. Freehold is a type of estate where the person has a right or owns title to real property for an unspecified amount of time. What is the difference between a freehold estate and a fee simple estate? A freehold estate is an estate in which you have exclusive rights to enjoy the possession of a property for an undefined length of time. In contrast, a less than freehold estate is held for a fixed, defined period. Fee simple absolute is the greatest interest in a parcel of land that one can possibly own. What is the difference between freehold and non-freehold estates? A freehold estate can simply be thought of as a property to which an individual owns a title and deed, while a non-freehold estate can be thought of as a property which someone pays rent to use. What is the main difference between a freehold estate and a leasehold estate? With freehold, you will own the property and land. With leasehold, you will own the property for a fixed period of time but not the land it is built on. What is a freehold estate? An interest in land which permits possession without interference from others. A freehold estate means ownership of real property. What are the disadvantages of buying a freehold property? The downside is that it might cost more to buy initially. Freehold properties are also easier to sell as the closer a lease is to expiry the harder it is to sell. Mortgage rates also increase if the lease is under 70 years. You can extend the lease on a property, but at a cost. What are the two major types of freehold estates? There are three types of freehold estates out there: fee simple absolute, fee simple defeasible and life estate. They represent an immovable asset in the real estate industry that you hold interest in. Each type of real property fits into a classification of ownership that determines what you can do with that asset. Does freehold mean you own the land? The freeholder of a property owns it outright, including the land it's built on. If you buy a freehold, you're responsible for maintaining your property and land, so you'll need to budget for these costs. Most houses are freehold but some might be leasehold, usually through shared ownership schemes. What are the benefits of a freehold property? Freehold is a lot simpler. You buy the home and everything associated with it is yours. You don't have any ground rents or service charges. There is no countdown on a lease, and no one else is involved in your ownership, you have much more control over your land and your decisions. What is an example of a freehold property? Freehold estates. Examples include the fee simple estate or the defeasible fee estate, which continue for an indefinite period and are inheritable by the owner's beneficiaries. Other freehold estates are referred to as estates not of inheritance or life estates, which exist only for the term of a person's life. What are the four freehold estates? Three of the most common types of freehold estates are fee simple absolute, fee simple determinable, and life estate. What type of ownership is a freehold? Definition: freehold property can be defined as any estate which is free from hold of any entity besides the owner. Hence, the owner of such an estate enjoys free ownership for perpetuity and can use the land for any purposes, however, in accordance with the local regulations. What are the characteristics of freehold? The Land Act specifies that the holder of land in freehold has the full power of ownership, which means they can use it for any lawful purpose and sell, rent, lease, dispose of it by will. How long does a freehold last? Freehold is where a person or organization has outright ownership, forever, of a property and the land it's built on. Leasehold is a long-term tenancy where someone buys the right to live in a property for a certain period, usually 99 or 125 years. What is not a freehold estate? A non-freehold estate is an interest in real estate that is less than absolute ownership of the real estate. It is created through a lease of the real estate. In fact, a non-freehold estate is often referred to as a leasehold estate. Is freehold property better than leasehold? Leasehold versus freehold, what's the difference? When you buy a property freehold, you own the building and the land it's on until you decide to sell it. But if you buy a property leasehold, you own only the building, not the land it's on, and only for a set number of years. Is it better to buy a freehold property? The benefits of owning the freehold of a property include gaining more control of the property, such as deciding how much to spend on maintaining the property, and which suppliers to use, instead of paying ongoing ground rent leasing costs. In addition to control, there is also independence from any landlords. Can you inherit a freehold? As it is owned, it is also transferable, and so it's common for people to pass freeholds on to loved ones as part of their estate when they pass away. A transferable freehold is an immobile entity, land and/or property, and with no time limit assigned to ownership. Essentially, it's yours until you decide otherwise. Who is the landlord of a freehold property? The land is owned by the freeholder, effectively your landlord, and you, the leaseholder, purchase the lease from them to temporarily own the property for however long is agreed in the lease. At the end of the lease, the property is legally transferred back to the landlord. Fee simple absolute is the highest form of holding title in real estate, in which the property owner has unconditional and absolute ownership of real property. When a person owns a fee simple absolute estate interest, that person has the absolute right to use the land, possess it, dispose of it. Fee simple absolute is an estate in real property, by which the owner has the greatest power over the title, which it is possible to have, being an absolute. Fee simple absolute, the highest and most complete form of ownership, which is of potentially infinite duration, also called a fee or a fee simple. Fee simple absolute ownership. Fee simple absolute ownership is the most protected and most common ownership status for a freehold estate. What is a domestic partnership? A domestic partnership is a type of relationship between two individuals who live together and share common domestic responsibilities, such as maintaining the property and caring for family members in the home. Is a boyfriend a registered domestic partner? A domestic partnership is an arrangement in which two people live together and are in a committed relationship without being legally married. It shares many of the same benefits as being married. Domestic partnerships are composed of two people of any gender, which includes male, female, or non-binary people. How does Fannie Mae define domestic partner? Domestic partner, an unrelated individual who shares, and intends to continue sharing, a committed relationship with a borrower who signs the note. In fee simple, subject to conditions subsequent, when conditions are not met, the grantor must take action. But in fee simple determinable, if conditions are violated or somehow not met, ownership of the property is automatically transferred back to the grantor. There is no further action required on their part. What is a fee simple on a condition subsequent estate? Fee simple subject to condition subsequent. The estate is similar to a fee simple, but has a condition attached, established by conditional language. These estates are followed by a right of entry. If the triggering event occurs, the holder must take steps to establish possession of the land. What is an example of a fee simple subject to a condition subsequent? An example of a fee simple subject to condition subsequent would be A to B, but if the property is used for commercial purposes, then A has a right of re-entry. Again, B has a fee simple interest in the property so long as the property is not used for commercial purposes. An estate in reversion is a unique type of estate. It allows one individual to hand over possession of his real property while he still owns it. In addition, it allows an individual to dictate who lives in his real property even after he is gone. A reversion occurs when a property owner makes an effective transfer of property to another but retains some future right to the property. For example, if Sarah transfers a piece of property to Shane for life, Shane has the use of the property for the rest of his life. Upon his death, the property reverts, or goes back, to Sarah, or if Sarah has died, it goes to her heirs. Shane's interest in the property, in this example, is a life estate. Sarah's ownership interest during Shane's life, and her right or the right of her heirs to take back the property upon Shane's death, are called reversionary interests. What is the definition of reversion rights? One retains a reversion when he gives his property to another for that person's use during his life only, and at his death the property reverts to the prior owner, or one may give his property to another to possess and use as his own only until the operation of a certain condition. What is the role of a reversion clause? A reversionary clause serves to protect the interest of the person or entity making restrictions on property and, in the event of a violation of such restrictions, title to the property subject to such violation may revert back to the reversionary party. A reversion is a future interest that an individual has in a piece of property even after he or she has conveyed that property, in a lesser estate, to another individual. Once the lesser estate has expired or ended, the property will return to the original individual. While the estate has been conveyed to someone else, the owner doesn't enjoy possession or use of the property. When the estate reverts back to the owner, they may enjoy possession once again if they so desire. A remainderman is a property law term that refers to a person who stands to inherit property at a future point in time upon the termination of a preceding estate, usually a life estate. A remainderman is a third person other than the estate's creator, initial holder, or either's heirs. What are examples of remainderman? A remainderman is a third person other than the estate's creator, initial holder, or either's heirs. For example, if Blackacre is granted to Thelma for life, and then to Lucy, Thelma has a life estate and Louise is a remainderman. What is the difference between the life tenant and the remainderman? Life tenant had the beneficiary entitled to receive lifetime benefits from a trust. Remainderman had the beneficiary who will receive trust assets after the life tenant has died. In the context of real property, a person who is entitled to receive possession of real property after the termination of the estate of a prior owner, such as in a life estate. Can a life tenant be a remainderman? The life tenant is the person who has the life estate, or entitlement to the use of property during their lifetime. The second party is the remainderman, or person with a remainder interest who is entitled to full ownership upon the death of the life tenant. Remainderman means an individual who is given a remainder interest in a property which he or she will inherit upon the death of the life estate holder. A life estate is property owned by an individual during their lifetime and prevents beneficiaries from selling the property before death. Who owns the property in a life estate? The property is owned by all designated parties in a life estate deed. However, the life tenant retains the right to occupy the estate. What are the disadvantages of a life estate? Life estate cons. The life tenant cannot change the remainder beneficiary without their consent. If the life tenant applies for any loans, they cannot use the life estate property as collateral. There's no creditor protection for the remainderman. You can't minimize estate tax. What is a characteristic of a life estate? Under a life estate, the owners have the right to use the property for life. Typically, the life estate process is adopted to streamline inheritance while avoiding probate. The life tenant retains all the rights and responsibilities of an owner except the right to sell or mortgage the property. What is a joint tenant? What is a joint tenancy? Joint tenants are equally responsible for things like rent. You have a joint tenancy if you and the other tenants all signed a single tenancy agreement. Your tenancy agreement has other tenants' names on it. Joint tenancy is a property ownership structure between two or more co-owners in which each person owns an undivided interest of the property, called joint tenants. In California, the majority of married couples hold their real estate property as joint tenants with right of survivorship. Can you force a joint tenant to leave? If your relationship breaks down, you can't force the other tenant to leave as they still have the right to live in the family home. This is known as occupancy rights. In these cases, the only way one of the tenants can be made to leave is by a court order. What happens to joint property when one dies? In the case of joint ownership, if one of the owners dies, his or her share automatically goes to the other joint owner, s of the property. However, in the tenants in common mode, the shares pass on to the legal heirs. Who is liable in a joint tenancy? If you have a joint tenancy, you are liable for the rent both jointly and individually. This means that one or all of you can be held responsible for the whole rent. It's not possible to argue that each tenant is liable for their particular share. What is another name for joint tenancy? Tenancy in common, TIC, is a method of ownership where two or more parties, referred to as tenants in common, share interests in real estate or land. More, with benefit of survivorship, what are the four unities of possession? The four unities are time, title, interest, and possession. Which type of ownership requires the four unities of time, title, interest, possession? Joint tenancy consists of two or more people owning equal, undivided shares in property. A joint tenancy requires unity of time, title, interest, and possession. What is meant by the four unities of time, title, interest, and possession? The four unities are time, title, interest, and possession. Time, they must take title at the same time. Title, they are all joint tenants on one deed. Interest, the ownership interest must be equal. Possession, they all share the property equally and they all have access to the property. Who has unity of time, title, interest, possession? Joint tenant. Unity of time, title, interest, and possession is vested in each joint tenant. Four unities. Each joint tenant has an undivided right to possess the whole property and a proportionate right of equal ownership interest. With joint tenancy, the right of survivorship is implied, so if one joint tenant dies, the other joint tenant or tenants automatically become the owners of the deceased tenant's interest in the property without the property having to pass through probate. What right means that if one joint owner dies? Right of survivorship. Joint tenancy has what is called right of survivorship, where, if one owner dies, the surviving owner takes all of the property, immediately upon the other owner's death. No court action is necessary for the surviving owner to take the property. In a community property state, such as California, any income, real estate, or other property acquired by either spouse during the marriage belongs to both spouses. Under community property laws, both spouses own everything equally, regardless of who purchased it or earned the income. What's the meaning of community property? Community property means that spouses who acquire property during marriage own property equally, 50-50. That means that one spouse on death can leave his or her share as he or she wants, and on divorce, it typically is divided 50-50 as well. How does community of property work? A marriage in a community of property is a type of marital regime where the spouses elect to have only one estate, and all assets and liabilities are equally shared. Usually, when a person gets married in a community of property, the spouses automatically become co-owners of all their combined assets. What is tenancy in partnership? A tenancy in partnership is a form of co-ownership in which all partners have an undivided interest in the property, but no rights to transfer their interests outside of the partnership. A partnership is a legal arrangement that can be formed between two or more different parties. A sole proprietorship is set up to allow an individual to own and operate a business. A sole proprietor has total control, receives all profits from and is responsible for taxes and liabilities of the business. What does sole proprietor mean in real estate? One owner business. A sole proprietorship is a one owner business. Unlike a corporation, LLC, or partnership, it is not a separate legal entity. The business owner, proprietor, personally owns all the assets of the business and is in sole charge of its operation. There are no partners in the business. The legal status of a sole proprietorship can be defined as follows. It is not a separate legal entity from the business owner. Is a real estate agent a sole proprietor or a corporation? Unless incorporated, a real estate agent likely reports income as a sole proprietor. This means that the real estate agent pays taxes on the full amount earned without deferral, separation, or the ability to split with family members. A domestic corporation is a corporation that does business in the jurisdiction in which it is incorporated. A living trust is a legal entity that you can use to distribute your property to people and organizations after you pass away. A living trust is a legal tool for financial planning that allows a person, trustee, to hold another person's, settlor's, property for the benefit of someone else, beneficiary. Unlike a testamentary trust, a living trust goes into effect during the settlor's lifetime. What is a living trust? A living trust is a legal arrangement established by an individual, the grantor, during their lifetime to protect their assets and direct their distribution after the grantor's death. Who is considered a limited partner? A limited partner has purchased shares in the partnership as an investment but is not involved in its day-to-day business. Limited partners cannot incur obligations on behalf of the partnership, participate in daily operations, or manage the operation. Investors in private equity funds are called limited partners. What is the difference between limited partner and general partner in real estate? Real estate limited partnerships. A limited partnership has both a general partner and a limited partners. The general partner is responsible for the day-to-day operations of the venture, while the limited partners serve primarily as investors in the venture. Limited partners serve only as investors in the business. Why are they called limited partners? Limited partners invest just their money in the partnership and have no control over everyday management. This also means their liability to business debt is limited to the amount they have invested. What is the benefit of being a limited partner in a real estate investment? Benefits of a real estate limited partnership. The benefits to limited partners include: liability is limited to the amount invested. Passive investment requires no investor involvement. Real estate tax benefits are similar to outright ownership. End of Unit 1 through 3.